Hello, I'm José Ramón Bengoetxea, José Bengoetxea, from the University of the Basque Country and the International Master in Sociology of Law at the International Institute for the Sociology of Law at Oñati. I am taking part in the session on Sociology of Law chaired by Gigi Priban, and this is taking place on Tuesday, 30th March at 3:30. So this contribution is largely based on my contribution to the research handbook recently edited by Gigi Priban on sociology of law, published at Edgar Allen. So Edward Elgar, I mean. The concept I'm going to develop is simple. The message is that in order to do research in sociology of law, it is obviously necessary to have some concept of law. This seems like a platitude, but what that concept of law is actually a matter for debate. It's moot. And certainly, if we don't have a clear view what law is, if we don't have some clear concept, understanding of what law is about, we are hardly going to be doing research into sociology of law, attempting to at least make sense and communicate with other members of the research community who also do, allegedly, research in the sociology of law, perhaps with a completely different understanding of what law is, with a different concept of law in mind, and therefore with the possibility of the research that is carried out by different researchers not being relatable, not being communicable, perhaps not being carried out along lines that can actually be shared and understood. So incommensurable, ultimately. So any research in the sociology of law, therefore, we would need to have a working concept of its object of study, of what law is. Now, how do we identify the law? What are the basic minima that we would need in a concept of law? Well, in my view, we can start by assuming that law is part of practical reason. That is to say, the domain which decides, deliberates, reasons as to what is to be done, what should be done, how it should be done, when it should be done. Therefore, the domain of practical reason, where law is but one of the discourses deciding and deliberating and reasoning on such issues, together with other fields of normativity, therefore is the starting point. I think a second step is to agree that the field of normativity, this field of practical reason, what is to be done, is framed by the presence of norms or rules, be they social rules, legal rules, political rules, ethical, institutional, economic rules, all sorts of rules are framing this field of practical reason. And because they are rules, they take us to a particular domain, which is the domain of normativity. This is the domain of the ought. The rules frame how decisions are to be made, what ought to be done. They give guidelines for action. Therefore, in that sense, the types of normative discourses that are done within practical reason are oriented to action, to guiding and justifying, of course, action by actors. Now, this domain can be the subject of at least two types of discourses: the discourses that actually engage in the business of normativity, and the discourses that try to explain, understand, describe such normativity rather than actually engage in the normative practice. So these discourses we can locate in what traditionally the social sciences have attempted to do. Therefore, we already have the sociology of law, which is going to be located in the divide between these two types of discourses. The law engages in practical reason, the sociology part engages in a descriptive, interpretive understanding of what normativity is, how it actually takes place, what the actors, agents understand by normativity, expanding the type of discourse. The interest of this type of discourse is not normative itself. The interest is knowledge based. So norms and normativity are the object of study, but in one case, it's the object of an engagement in the discourse, and in the other case, it's the object of a description of how it operates and how actors see it. Of course, norms are not in isolation, and in the law, legal norms tend to group together into sets that are related depending on the subject, depending on the authority, depending on the types of sources which originate them, depending on the normative coherence that brings them together. They, in that sense, sets of norms tend to group together and to create a legal order. And this concept of the legal order, again, can be also, just like norms, and normativity, be the subject of the two types of analysis. The analysis that looks at the group of norms and the formal structural relationships, their hierarchical structures, creating a sort of system, and on the other hand, an understanding of order that includes much more the attitudes of the agents, the attitudes of the actors, perceptions about the law, legal cultural aspects, how the different institutions deal with that set of norms. And here again, we have an interesting contrast that we can study. We can study this set of norms from the normative discourse perspective. We can try to analyze also its operation. And here again, a sociology of law would have a sort of balance between the two perspectives, just like when understanding particular types of legal norms, we would have an approach which is based strictly on the normative discourse or on the social dimension of and descriptive and knowledge-based interest. We also, when analyzing the concept of legal order, we would have a more formalistic understanding and normative discourse made about the relationships between the norms in the legal order, as opposed to a more sociological understanding of the legal system, including its actors, its operation, its action, the law in the books for the legal order, the law in action for the legal system in the sociological sense. And this, of course, also takes us to the next, if you like, more removed step. We have moved from the norm to the order, and now we move to the whole understanding of a law, a type of law, a state law, international law, the law of a particular religious group, as analyzing strictly the formal constitution and the formal structure of that law, and a more open, pluralistic understanding that doesn't look at that law as such in isolation, but rather tends to look at their actual interaction in a particular society, in a particular community, how they actually are interacting. This takes us to the broader concept of legal pluralism, but perhaps in a more technical sense, analyzing the interlegalities between such concepts and of, of, of laws, different types. This interaction can take place with specific types of norms, with concepts of legal order and system interacting, or with actual more cultural understandings of what laws are about. And this takes us to an interesting notion of pluralities and interlegalities, and how often there is interference from one system to the other. We see this clearly in the European context, in a more multi-level dimension between regional, national, state, and supranational interactions, interlegalities, but also at a more parallel levels and more pluralistic contexts, by different types of social norms that are applicable in society. Take family law, how different types of legalities are coming into contact and facing each other in different areas of the law, family, even contract in some areas, property perhaps for some other cases, but mostly, of course, family law becomes crucial here, but also in more modern, digital, if you like, areas of the law where such interactions can actually also take place, and interlegalities are looking very much into what other norms are being developed in other types of legal systems, perhaps looking for solutions, comparative law-based understandings and solutions. So all these interactions and understandings and all these possible approaches to discourses that look more at the formalistic level or more at the sociological aspect of the operation of law, probably can be grouped together or lead us to a concept of law that is useful for sociology of law. I believe that McCormick's concept of law, understood as institutional normative order, is precisely the type of understanding that can contribute enormously to this basic understanding of what it is that sociology of law should be looking at. Therefore, this includes, of course, the normative, the order aspect, but of course the institutional dimension, institutions being sets and groups of norms on particular types of issues. They can be agencies, in which case we would be looking very much also at powers. They can be arrangements of norms. Contract would be an interesting example. Or they can be actually things, institutional things, so shares or money or stamps or prisons. They become all these sorts of interesting approaches where norms with different actors are actually engaged in the game of normativity, but also in expanding concepts, opening themselves up to other alternative conceptions, to pluralities, and to other understandings. Therefore, that would be my contribution now to this session, and I am of course open to questions, comments, and discussions. Thank you.